Okay.
Troy, do you want to do? Are you recording now? You are. So you want to start?
Yeah.
Yeah, I'm going to start. Yeah, this is going to be my edit point, so I'm going to end up cutting all that other stuff out. So here we go.
That's the best stuff.
I know.
All right, you know what? We're going. We're going to start. Welcome everybody to the Steve and Troy Show. It's not the official title, but that's how we refer to it in our notes. This is a program that Steve and I put together for IEPPV.com. We're a local Southern California camera group. We also have teamed up with PPOC, which is Professional Photographers of Orange County, San Diego, TWIP, a bunch of other groups. So we're kind of reaching out to everybody. I see a nice list of friends and names and stuff in there. So welcome everybody. You guys know how this works already, right? If you have any questions, put them in the chat. We'll grab those as we go. You can talk amongst each other. Steve, why don't you introduce our amazing guests tonight, and then we'll let them take over.
Sounds good. So again, to everybody, thanks for joining us. And I've been super excited about this because I've met these two gentlemen before, Jack Reznicki, Ed Greenberg. Jack Reznicki you can find, just so that you know, at reznicki.com. And then Ed's law practice is greenbergiplaw.com. And Jack is the photographer, Ed's the lawyer. They've been on my podcast twice, as I recall. And just really fun guys, and they also run the Copyright Zone. So if you've ever been to the website, thecopyrightzone.com, or if you've ever checked out the book, The Copyright Zone, which is on the shelf behind me here, it's kind of the definitive guide to copyright for creatives or photographers. So with that in mind, you guys want to take it from there, and let's see where we go.
Sure, you just killed my first 5 slides, but okay.
Okay.
Well, put them up anyway, so it's in the video.
Yeah,
so
no, we're going. Let me share this. Okay. And there we go. Play. There we go. So again, awesome. I'm Jack Reznicki. This is Ed Greenberg. This is the book that he mentioned, The Copyright Zone. If you can get your hands on it, I think it's getting harder and harder these days. The only thing I will say about this is the step-by-step of how to register is no longer applicable. So that's been updated, and what we have, everything else is perfectly fine. It's a very thick book, but the step-by-step has changed. I think Steve has something on one of his sites on how to go through it.
I have a video of my step-by-step if anybody's ever interested in it.
We'll go into registration in one.
Really?
What's that?
It's surprisingly good. And let's remind the folks, Jack, before we break for commercial, that the book
is the commercial. This is the commercial.
That's right. That the book is only partially about copyrights. We get into model releases, rep agreement, how to hire a lawyer, how to kill a lawyer, etc.
Yeah, more jokes there, and a wedding contract and a lot of other things. So this is our blog, The Copyright Zone. It's pretty infrequent. We have quite an archive of a lot of good articles, usually stuff that other people aren't talking about, or we'll delve deeper into some issues because we find out that a lot of people, when they write about copyright, they just read the press releases. They don't read the court transcripts. And we found some very, very interesting thing reading the court transcripts of what actually has been going on. So that's one word, thecopyrightzone.com. Like I said, we're a little infrequent. We sometimes have a rush of stuff, and lately we've both been busy. So.
And one other quick note, trust but verify. Most of the things that you read in newspapers, magazines, including trade magazines, are about legal cases, are largely incorrect. They omit a lot of material. In fact, I had correspondence today with a woman who wrote the lead story for the New York Sunday Times magazine section. The article is entitled, "You Don't Own Your Face." And the article is essentially completely wrong.
But we'll go into that later because we got a lot of stuff to cover here. We're going to do an all over. We're going to touch on a couple things first, then we're going to do basic copyright, and then we're going to go into some current cases like Lynn Goldsmith's decision that we think is quite huge, quite frankly. So again, if you want to reach us, this is Ed's email. Steve was nice to give you our websites, but this is both our emails. And just so that there's no confusion, because there has been sometimes, Ed is the lawyer, I'm the photographer.
I have a tie on. How could anybody be confused?
Oh, I'm not going to say it. There's a lot of misconceptions about copyright. It's just amazing, mostly on the interweb. So much. The problem with quotes on the internet, if you Google this quote, you will find out that it's attributed to Abraham Lincoln, which I think is indicative of just how bad things are on the internet. We also saw this a couple years ago. Can I use this picture? And it looks great. It's designed wonderfully. It is horrible. This will get you into a lot of trouble. It is a lot of half-truths, misconceptions. And one of the things that also drives me crazy when I see these, if I see anything where words like brochure are misspelled, you really got to think about it.
But
it looks good.
But it looks really good and it flows really nicely. So people get sucked into believing the content, which is basically garbage.
Yeah, especially words too, like usually safe. You are usually safe to use the image. Yeah, you usually might get sued too. Yeah. That great boxer and philosopher that we all love, Mike Tyson, once quoted to say, everybody's got a plan till they get punched in the mouth. And we find that out with copyright. And that's on both sides. We find out a lot of photographers get very educated about copyright when their work is ripped off, and they find out what they don't know about copyright, and they get educated very, very quickly. Also, if you ask creative types, photographers, artists, anybody else, things about legal questions online, 10 creatives will have 20 opinions, and 19 out of the 20 will likely be 100% wrong. And we see this time and time again. One of the big mantras we have is do not discuss copyright problems you might have on the internet. It's discoverable by the other side, even after you take it down. Lawyers love something called the Wayback Machine, where they can get a picture of the internet going back till the beginning of the internet, just about. So anything that goes up is findable.
It goes for any legal disputes that you have of any kind. Only conversations between you and your spouse, your rabbi, your priest, your minister, your doctor, or your shrink are privileged. Your best friend, who has preserved every secret you and she have ever had for 45 years, she gets served with a one-page subpoena from any lawyer, and she's going to be forced to tell your darkest secrets. So don't talk about them on the web. Don't make social posts. Keep it private between you and your attorney.
Well, luckily I have no dark secrets, so I'm fine. So
yeah, how about that night in Poughkeepsie?
We won't talk about that. Hey, so I picked my toes.
I should have worn the shirt. Did I get the shirt? You should have worn
the shirt. Well, you'll tell the story. You guys might have seen this recently about Jeff Sedlick suing Kat Von D over a Miles Davis tattoo. And this is still going on. Ed and I know Jeff very, very well. This is the picture.
Is he going to change into the T-shirt?
Oh, God. I shall continue.
Okay.
So this is the picture. She tattooed it to somebody. Oh, good. He still has clothes on. So
I'm getting the shirt.
Yeah. Change off camera, please. So Kat was putting this on social media. She was proud that she ripped off his picture. And here she is with some more stuff online. And what we're going to talk about is a lot of the stuff that was talked about on social media. This is ongoing. Jeff is one of the experts on copyright in court. In fact, him and I have both been on opposite sides as expert witnesses in copyright. There, you got the T-shirt, Ed? Okay, let me finish this section and then you'll tell the story about the T-shirt. but it's a very well-known image. So this is some of the stuff that we've been reading online when this came up. And I love reading some of the comments. And I've learned to stay away from leaving any type of a comment because I don't want to start arguing with some of these people. Photographer doesn't understand copyright law. It's just a photo. Right. Greedy photographer asking insane amount of $150,000 per use. Well, actually, that is determined by copyright law, that it is up to $150,000 per use. That's the law, not something he made up or pulled out of thin air.
For a willful infringement.
For a willful infringement, and we'll be getting into that. Also, it's transformative because it's in a new media, namely a tattoo. And we'll go into things where we'll show you photos that have gone into sculptures, and it doesn't matter. It doesn't matter that it goes into a different media. It's still your image. A 32-year-old photo, I don't know why that matters, 32-year-old photo has been widely distributed and reproduced for decades, uses the basis for a drawing on an arm. This will get thrown out of court. We can guarantee you it will not.
Can I pick up on this?
Yeah, go ahead.
Whoever posted that is either a really dumb lawyer, of which there are many, or someone who has no legal training at all. If a photograph has been used and licensed and relicensed for 32 years, it, by virtue of the length and extent of licensing, proves its value. So now I'll do the quick story. First of all,
this I'd like to hear from you.
This is the quick one. First, for you jazz fans who are familiar with Miles Davis, you know that one of his great inventions in jazz is that not playing a note is musical, that silence is part of the music. So when Jeff shot this and Miles is doing this, at that particular time, that has a meaning among jazz and jazz fans. Meaning quiet, that sometimes quiet speaks more than words. This coming from a talkative New York Jewish lawyer. But
yeah, I was just thinking, I'd love to have that tattooed on your arm.
Yes. So the quick story is I was in St. Thomas with my wife in the area where there are all the shops for the tourists. And my wife, because she's Jewish, was, of course, shopping. It's genetic. And one of the guys came over to me, and he sees me wearing the shirt. He says, go to the end, 2 blocks past the tourist section, and there's a bar there. There's a neon sign, and it just says bar. Go inside. And I
promise we will be getting to copyright.
Right. And I take my wife, and I walk in, and I'm wearing this shirt. And the female bartender yells in the back, and she says, Bobby, come out here. And Bobby comes out. And Bobby takes one look at me, and he's a native from St. Thomas. And he says, you two eat and drink for free all day. Just take care of my waitress. Because the bar plays nothing but Miles Davis all day long.
And so, that's why Ed was the only person eating in that restaurant. So
I was also drinking at 11 o'clock in the morning.
So Ed, we got to move along because we got a lot of stuff we want to get to. But I always love the story too. We just got to shorten it up. So I love this part. Somebody posted, I wonder if Kat Von D was more likable, this wouldn't be as big of an issue. And then somebody answered, shoot. We won't know what somebody answered because this is the beauty of Zoom. Because I moved something, I now have to go to stop share, get out of Zoom, and go back into share again. I've learned this the hard way. I won't move anything else. So somebody said, oops, where's play?
There it is. Good to know.
Yeah, I got it. Somebody said, good to know that being unlikable is reasonable grounds for prosecution and suit, which somebody else answered, who probably was a lawyer, who said, you say that in jest, but in the medical profession, being likable or not is the single biggest determining factor on the quality of lawsuits one will attain. Actual medical proficiency doesn't correlate to the lawsuit amount. weird, right? Whoops.
To which,
weird, right?
To which I added that a likable client and a likable witness will always get more money than someone who is unlikable. Juries like likable people. And Disney, when you go to Disney World and everybody's really nice to you, Walt taught them that because it makes money.
Well, funny you mentioned that, because that's going to be in our next slide. We'll tie right into that. This is the last one, I promise. If I love this, we have this whole thing about 10 myths of copyright, and we're adding this one real soon. If I remember correctly, if you make at least 3 changes when using someone else's art, then it's no longer copyright infringement. They've been teaching this in art school, that if you change 10%, 20%, 30, 40%, it's a new image. Not true at all. We'll be going over some of that a little later in derivatives. I do a lot on derivatives in this. And the other was, she won't be taking any work from the photographer. They are completely unrelated fields. Doesn't matter. And what drives me absolutely nuts is this cartoon I saw online once. And it has to do with derivatives, which, again, we're going to go deeply into. And that's this cartoon that said, this says if you change a piece by artwork by 20%, then it's your artwork. Really? I can get a copyright and everything? Yeah. And then where are you going? To get an agent is he's partly Mickey Mouse. Completely 100% false. And so this is why we say, do not listen to things on the internet. It is just it is most likely than not a bad source of advice.
And the obvious question is, when you say change 20% or 5% or 10%, what does that mean? So in some of our lectures, we use a photo of me smoking a cigar, which is in a book, and the photograph of my face takes up maybe 3% of the photo. The rest of the photo is my cigar in the Empire State Building. So the question is, if you replace 3% of the pixels with Ronald Reagan's face, as opposed to mine, have you changed the picture entirely or 3% worth? So the whole concept is nonsense on its face. No pun intended, or pun intended.
Pun intended.
Pun intended.
So we're gonna go into the basics now of copyright. You create it, you own the copyright from the moment of image creation. You own the copyright instantly. As soon as you snap the shutter, you own it. If you're an artist, the moment you put paint to canvas, you own it. If you're a writer, as soon as you write the words, you own the copyright from the moment of creation. And that's since 1978. Before 1978, things were a little different. You definitely had to register to have a copyright. But since 78, since the US has been the signatory of the Berne Convention, you don't need to do anything to have the copyright. But, and this is a big but, and this is from our book. We have a lot of cartoons because we know who reads our book. While it exists from the moment of creation, it's worth a bucket of spit without the registration. And that's a quote by me. We're going to go into why, if you do not have it registered, your copyright, I can't say worthless because Ed'll jump down my throat being a lawyer, but it's effectively worthless.
You can't go to court. You can't sue anybody. Well, unless you have a physical registration in your hand, you cannot start a lawsuit, period.
Ed, you're getting ahead of me, and I don't know why I just lost this. I'm trying to pay attention on what I got here. Oh, here we go. Okay. Because I can't see everything. Okay. So what is copyright? Copyright is the right of ownership to your intellectual property, and it's written directly into the Constitution. And when we say directly, this is where it is. It's Article 1, Section 8 of the U.S. Constitution. It says Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And that covers any type of creative thing. Photographs were specifically mentioned and added on in 1865. I actually had somebody write an article that I saw, and they said, oh, this photographers, didn't get the right of copyright till 1978. I said, no, it's been around since 1865. Now,
No, it's actually been around before you had the right, before you got your First Amendment rights, before you had your Second Amendment rights, before you had.
Well, you're getting ahead of me, Ed. You're getting ahead of me. It predates all the amendments. It is the only right in the Constitution given to the people. The only one. So it does predate the freedom of speech, freedom of the press, freedom of religion, the right to bear arms, and our personal favorite, the repeal of prohibition. So copyright is not going to go away. It's not going to get outdated unless you want to rewrite the Constitution. As some new people have been saying for quite a while.
And one of the points here is that if someone asks you to give up your copyright rights, you're giving up constitutional rights. It's heavy stuff. This is stuff that the founding fathers thought was so important that they put it in there before freedom of religion, freedom to carry a gun, freedom to vote. That's how important they thought it was.
And the concept is, and it's true in other countries, and other countries are finding out the same thing. If you do not protect creative people, you do not get as much creative works produced. And that really is the bottom line on it. It is to help promote the further science and useful arts. And without protecting creative people, you just don't get as much done. So that is the thought process behind it. So what is copyright specifically? There's something known as the bundle of rights. And the bundle of rights is also referred to as your exclusive rights. Same thing, bundle of rights, exclusive rights. And these are the 4 rights. There's actually a 5th right that I don't have here now. It's the right of reproduction. The copyright owner has the right to reproduce the work or not reproduce it. You are also protected on all derivatives, and that causes a lot of court cases. The recent Lynn Goldsmith case really was about derivatives, and we've seen a big problem with that with the art community and appropriation art, and we're going to go deep into that because that is a very confusing area.
But now, just know that a derivative is a version or bastardization, depending on the facts, of the original work. Something's been changed.
Yeah, it's like you do a movie from a book. The movie is a derivative of the book. In fact, that was one of the things quoted in Lynn Goldsmith's case, is they referred to many times to different movies and how movies like Scorsese's The Irishman is derived from a book. And even though it's say that 5 times fast, Scorsese's film, and it has his imprint and his style, it's still a derivative, and he has to get the rights from the book author or whoever owns the copyright to the book. So your other right is the right of distribution. You can say, I only want my picture distributed in this form. I only want it distributed in this geographic area. I only want it in California. I only want it in the New York tri-state area. I only want it North America. I want it all over the world except in France. You have the right of how your work is distributed. The right of performance doesn't affect us. It's part of the bundle of rights, but it's for the performing arts, like musicians and plays and anything like that that can be performed, that's protected. We do have the right of display. You can say, I only want my work displayed in a color image or only in black and white. I don't want it colorized. The copyright owner has that right to determine how the work is displayed.
More typically, under the right of reproduction, distribution, and display, most typically is in a commercial advertising situation. You are licensing or agreeing to give those rights to a particular client. So you can reproduce my photograph of the new Chevy Corvette and distribute it to all the Chevrolet dealers to be displayed only in Chevrolet showrooms. No use
For a specific period.
No
for a specific
television.
period of time.
No social media starting on January 1, 2021 and terminating on December 31, 2021. So that shows, that's the typical bundle of rights that a commercial photographer is going to license to his client. At the end of that term, the photographer gets back everything. He or she owns everything that he or she has permitted Chevrolet to use.
So, Jack, can I interject a question here?
Sure. Please.
There's two questions I think that relate specifically to this. I'll start with Shane Foley. Says, education exception question. Is it correct that an educator can use a work and distribute it to their students if that work is not part of their regular curriculum, or does that even apply here?
There's a big problem with that, and being an instructor, the schools have been very good at trying to educate their own teachers. It depends. You can't take a chapter out of a book and distribute it to your class. That's a violation of copyright. You can do a small section, you can refer to something, you can do some quotes, or Ed, correct me if I'm wrong, but something like a page, but it has to do with the amount of it. If you are impacting somebody else's ability to sell that book, then you're in violation of his copyright.
That's the key. So let me fill in a little bit here. Let's take, I'm going to go back to dreaded and disgusting law school. A law school teacher or professor, like they like to call themselves, could use articles in a newspaper about an ongoing case of any kind, whether it's a Harvey Weinstein type case or any other kind of political scandal case. They could use those photographs in an instructional setting for their class for the purposes of teaching about that case. So my favorite example, because I'm involved in it, is we represent Richard Noble with respect to a photograph of Bo Jackson, the athlete, which is a very, very famous photograph.
Luckily, there's enough people here with white hair so that they know who Bo Jackson
and it's the photograph of Bo Jackson with the shoulder pads and the baseball bat. It is arguably the most valuable advertising photograph ever taken. In any event, when Photo District News was alive and did a story on our lawsuit against Nike, it discussed the lawsuit and it showed the photograph. It did not need a license from Richard Noble, the photographer, because the article was of and concerning a litigation which was concerning this photograph, which made it fair use. There is an education exception where a teacher uses a small portion of something that may be separately copyright registered solely for the purposes of educating a class. And those cases are those cases are very, very difficult to even discover, and most professors are smart enough not to just give out the entire copyrighted item, like Jack referenced, for example, a copyrighted book or screenplay.
Okay, so let me just let you know what the second question is, and it may better fit later, and I'll bring it back up later, but just in case. Question on composites. What if we take images of artwork in museums and public places, but then composite it with elements that they create on their own?
If in a museum, if it's something before 1923, odds are it's in public domain. If it's a piece of artwork outside that you're getting, like graffiti or something painted on the side of a building, which Ed had something about recently, you're going to run into problems. because those things are probably, you have to assume that that's under copyright, and you can get sued for that. And putting it into another thing doesn't matter. We'll go more into derivatives. I don't want to go too deep into that.
No worries.
But
You go ahead and keep going.
Yeah, at this point, you guys can understand why, as a photographer, I get paid by the slide. Ed gets paid by the hour. So I'm going to keep trying to reel him in. But there's two things that I did want to talk about. What Ed talked about, the licensing, is the mistake a lot of people make is they don't put a specific time, meaning from this date until this date. You don't put 1 year or 2 years. When you do that, it's too vague. The client can wait 8 months, to before he does his what they call first insertion or first use, and as a result, they're extending their license. You want to be very specific from what date to one date. Also, a lot of things Ed said. He said, as far as distribution, no billboards, no TV. The word "no," and I'm going to put that down here, is one of the unwritten rights you have, is to say no. The right to say no.
It's the
one of the terms. Yeah, the one term that I put in a lot of my licenses is no third-party usages. So if you take a portrait of somebody for, say, real estate company or a bank, and they use the portrait of the guy, and then that salesperson goes somewhere else, you don't want them using that picture for a competing company or competing bank. So you want to put in your terms no third-party usages, and that will protect you. I just had something with the Washington Post on something I licensed, and that was one of the terms I made sure I put in. I knew that they were going to be distributing it through their
wire
distribution
service
thing, the wire service. But I put no third-party usages. As long as it was connected to the Washington Post, it was okay. But I did not want that being distributed by somebody else.
Now, let me throw in a practical example from the advertising side. You do a job for Home Depot, and it's essentially a straightforward ad for a lawnmower made by Toro Lawnmowers. You do not, unless you're getting paid for it, you do not want Toro to use that ad at another hardware store or on their website. You are licensing Home Depot to use it only in their stores or their websites. Toro's got plenty of money, and if they want to use it, let them pay you.
Okay, we're going to keep moving on. So how long is your copyright good for? Works created after January 1st, 1978. It's for your lifetime plus 70 years. Your kids, your grandkids, and your great-grandkids can collect. And I know a lot of people who are living a pretty good income off their parents' very famous career of images. I won't name anything specific, but I've been seeing a lot of that lately, and they know the licensing, they do the licensing, and the estate gets it, the kids get it. It's a really good thing. This has happened since 1978 on something known as the Copyright Term Extension Act, also known as the Sonny Bono Act. This was something that Sonny Bono pushed through Congress, and his name is attached to it. So I want to talk about copyright registration. What do you get from it, and why do we say it's so important? Why do we keep emphasizing it? Because it is important. There's a bunch of issues. The first and most important thing is, Ed said earlier, it's the ability to file a lawsuit. Copyright infringement cases can only be heard in federal court. You can't go to small claims court. You can't go to, and I'll talk about the Case Act a little bit later. That's not a court. That's a process. But the ability, if you can't file a lawsuit, the other side knows you can't do anything. All you can do is sit there and, turn blue in the face, like we have in our previous slide up a lot earlier.
That piece of paper is literally the key to the courthouse. So if I'm representing an infringer and I get a letter from a photographer or a search firm like Pixie, and they're making all kinds of claims, I write back typically in a semi-obnoxious style, you didn't send a registration. When you have a registration for this image, let me know. In the meantime, lose my number, because I am going to ignore you.
If you get ripped off and you try calling an intellectual property lawyer, and that's who you should be calling, not just a lawyer you know. It should be somebody who deals in these things, an IP lawyer, intellectual property. First question they ask you, and it's always the first question, is the work registered? If it's not registered, odds are they're going to turn it down. Now, Ed has, no, I know. Ed's going to jump in on this because Ed will take a look at the case, because there are cases where even though it wasn't registered before the infringement, because of the value of how it was used or other situations, it could still be very valuable. But Ed, you have to agree that the majority of lawyers, if they hear there's not a registration, are going to make a face.
Well, the majority of attorneys who take these phone calls are idiots. It's like saying, I'm going to give you a car for free, and you don't look at the car. So we've had cases, one, the most famous one, which was not my case, my client, but he had another attorney, unfortunately, at the time. He registered, quote unquote, late, and he only got $2 million. And he registered just before he started the lawsuit. I have prosecuted many lawsuits for photographers who, quote unquote, registered late. If you are a photographer who is of, let's say, an Avedon reputation, or the job is a 2, 3, 4,
Mike Seliger type,
right? Or it's a $200,000, $300,000, $400,000 job. The fact that you're registering late makes no difference. If it's a job that's a $5,000 or $10,000 job, it makes a big difference. So before turning it down, a smart attorney, of which there are a precious few, you have to get the information on the reputation of the photographer. What is the licensing history of the photographer? So going back to Jeff Sedlick for a moment, let's assume that Jeff never registered that image, which is, of course, impossible, but let's assume he didn't. If he came to me with that case and he can show sales over 32 years by 25 different companies, and we have to register it today, I'm all over it. Fine with me.
Yeah, and I will have to say to everybody, that's more the exception than the rule. You really need to have the work registered. And even with this new Case Act, one thing that's skimmed over, there's two facts about the Case Act that's skimmed over. One is the work has to be registered. And if you start the process and you can't get the registration certificate within a year, then it just goes away. You still have to have the work registered.
I fear some confusion. What Jack is referring to accurately and remarkably accurately, the Case Act is the so-called small claims court, which we'll get to later.
Yeah. The other issue, in case we don't get to it, the other issue with it is if you approach someone and say, you've infringed, we're going to go to this small claims process. It's not a court. And the other side could simply say, no, I don't want to. And they can do that without any prejudice, meaning there's no damage. If they end up in court later, which is where you have to go after that, there's nothing, the court will not look anything at that and saying, oh, you didn't want to do this. If you don't want to do it, you're just not going to do it. It's really more arbitration and mediation than anything else. So let me continue. So we're hammering this home because this really is important. If you can't file a lawsuit, it's a huge, huge problem. And as Ed said, even if he takes a case where it hasn't been registered, he then still has to get it registered in order to proceed. You can register after an infringement. I think that's what Ed's really been trying to hammer home, that you could be infringed. It wasn't registered, but don't contact the infringer. Go to a lawyer right away. And if there's a real case there, you will get a registration, an expedited one, which we'll go into also. Actually, I don't know if we will, but yeah, when I go to costs, we'll tell you what expedited costs. Here's the other thing. If you register your work before an infringement, there's two things that you get from registration. You can get compensatory damages or statutory damages. Compensatory damages are actual damages. How much have you licensed this image for? How much do you usually get for this type of image? That's compensatory damages. And if that's only a couple $1,000s, that may not be worth it to pursue a case. But statutory damages is what we talked about earlier, which is if you can prove willful infringement, like somebody removed your copyright notice or your watermark on it, that's proving willful infringement. And willful infringement can go up to $150,000. So that's plus, well, that's the next one. If you've registered before infringement, you can recover your lawyer fees. And in some cases, that scares the other side more than anything else, because the lawyer fees can be much more than the damages.
And very important here for any photographers out there who have made the mistake of dealing with any of these search and settle firms like Pixie and its competitors, you are not entitled by law to receive any money for any fees that you were to pay to Pixie or PickRights or any of these other companies. And in real life, juries don't want to give them money either. So if a photographer is on the stand in a case that was generated by Pixie, if I am representing the infringer, I say to the photographer something like, other than your attorney and your spouse, if this jury awards you any money, other than you, your spouse, or your lawyer, does anybody get any money? And the photographer were to say, well, yeah, my search firm gets 30% or 50%.
No, 50%. They get 50%.
Whatever it is, because it varies. You know what the jury does? They cut that award by the amount that the search fee gets, because I will put a witness on for the search fee for the search company and say, how long did it take you to find this image? 5 minutes. Why were you searching? Oh, we wanted to start a lawsuit. How do you think juries react to that? Do you think a jury wants to give them 30% of a judgment because they spent 5 minutes looking to fabricate a lawsuit, even if it's a legitimate lawsuit?
There was an article a while ago about a couple in Australia who said, oh, they got this much in damages in a lawsuit, but we only collected X amount, which was 15%. And when I read it, I knew exactly what the issue was, and they didn't discuss it. What the issue is, they used one of these search firms that took 50% of what the settlement was. I don't remember if it was a settlement or a judgment, but they took 50% of that amount, and their lawyer took 35% of that amount, 30 or 35. They ended up with either 15 or 20% of what the actual amount was. So you want to be careful when you get involved in these things. Also, some of these search firms all they really want to do is a quick settlement. If somebody offers them a couple $1,000s, which sounds good to most people, they will settle very quickly, and you'll suddenly get a check in the mail for $1,000 or $2,000, and you're thrilled. Then if you go to a lawyer like Ed and he looks at it and he's seen this time and time again, he'd say, oh, this case is worth $30,000, $50,000, $60,000, not just a couple $1,000s. So they're looking for their whole business model is quick settlements, because the more time they spend on it, they lose money.
So the people that they use to settle these lawsuits are 99% of the time, not lawyers. They have no idea the value of the case. And most importantly, once they find an infringement, they stop looking. Our office and any other competent law firm doesn't do that. if our photographer, or if it's in the case of a model, the use of her image, if he or she finds it being used at CVS on Fifth Avenue in New York, we don't assume that that's the only place it's being used. In fact, we assume it's being used by, at the very least, CVS everywhere in America. So
yeah, I'm gonna cut you a little short, Ed, because we're way behind on stuff too. It's basically what he's saying is you don't know if you're looking at the tip of the iceberg. The real infringement could be huge compared to the little bit that you're seeing. And that's what Ed is trying to tell us here. So the other thing that you get from registration is you can get an injunction. If it's produced like on clothes or a box or on hats, any which way, you can go into court and get an injunction saying, I want it removed from commerce. I want it removed from the market.
And the cost of doing that, if it's a package, like we've had cases that has been or is on the shelves currently at CVS, Walmart, Walgreens, etc., the cost to take that product down and repackage it is often enough to settle the case.
Yeah, and Ed has done that. The one I liked is the Peter Brandt picture on a dress. But we shall continue. So injunction. The other thing you get is prima facie evidence, and that's just that if you've had it registered for X amount of time, you don't have to prove that that's your picture. That's assumed in court that your registration is prima facie evidence. And
they
by
have
the
to
way,
prove, hang on, important. They have to prove that you didn't create it, which is, unless you outright stole it, is virtually impossible.
Now, we're talking just about registration is here in the U.S., but the funny thing is that other courts that I've been reading about in other countries are actually accepting a U.S. copyright registration as prima facie evidence that it's that person's picture. So it is accepted in other courts. There's no legal qualifications for it. There's no legal thing to it, but the court will say, okay, if you've registered there, that's evidence in our court. So this we've hammered to death, basically, without a registered images, which means without the possibility of bringing a copyright lawsuit, many infringers know that they can simply ignore you. And that's what happens. So where do I register? Glad you asked. You go to, the easiest way to go is to go to copyright.gov. Do not go to copyright.com. And from there, they've got a lot of good information. It's a wonderful site. A lot of tutorials and stuff, but you want to follow the breadcrumbs to the Electronic Copyright Office, also referred to as ECHO, little e, capital C-O. At least that's the way I pronounce it. When is the effective date of your copyright? It's when the Copyright Office receives all the required elements in accepted form, regardless of how long it takes to process the application and mail the certificate. So as soon as I hit, I'm done uploading my stuff to the Copyright Office, if I do that today is the effective date of my copyright registration, but it might take 4 months, 6 months, 8 months to get the actual certificate in my hand. Somebody just wrote to me who said, gee, I just registered some stuff in January. I haven't gotten the certificate. He thought it was automatic once he sent everything in. The computers did it. No, I said it ended on somebody's desk. If they suddenly got a whole bunch of work from Disney to register, your work might take a little longer to get to before you get the certificate. Or it might land on somebody's desk and you get it a month later, which has happened to me, and I was shocked when that happened.
And on top of it, the pandemic has a lot of people from the Copyright Office working from home. And I have found that the people at the Copyright Office, as opposed to most government employees, actually know their jobs and are very good. Since they've been working at home, I don't get the sense that they're working terribly hard.
I will say, though, if you do call them, it might be a wait to get somebody, but once you do, they're very nice and very, very helpful, which is unusual for a government agency, but they are really nice.
They've been amazingly helpful for me. The longest I've had was about 8 months to get it back, but when you get them on the phone, like when they've emailed me and said, call me, there's an issue. I can't open your zip file, is what happened to me. They were great on the phone.
They were, Steve, they were really nice to you, right?
They were, I mean, seriously, it was like dealing with a private company. They were
Right,
fantastic.
it proves they didn't know you. But
yeah, exactly.
they,
let me inject. I know you're behind, but let me just
really
inject this one.
You're right. You are.
I've got a question I'm going to save to the end, but this one fits right now because I think you just answered it. This is from Stephen Scharf. What is the lead time for getting an image registered? I'm thinking of a real estate photographer who does a designer shoot, and a manufacturer of, say, appliances or furniture picks up the image and uses it in an advertisement.
You can, you can if you want to start a lawsuit, and you very, very rarely need an attorney to register a copyright. My office registers maybe 3 copyright registrations a year. But if he's done the shop and he wants to start a lawsuit right away, and he's got a valid lawsuit because he's gone to an attorney who knows what he or she is talking about, for a fee of $800, you can expedite the registration, which used to mean, I should say, that you'd get a physical piece of paper registration within an hour if you were at the office in DC, or within 48 hours. These days, expedited means 2 weeks, give or take. So
or 3. But
what it means is that he should expedite it so he can start the lawsuit, or at least his attorney can say, I can sue you tomorrow because here's the registration, and dangle it in front of the infringer, and not have to wait 6 or 8 months.
But Ed, this guy doesn't necessarily want to sue. He's not at that point yet. He just wants to know the timing for the registration, and this is what it is. You can register a work you have to register a work either unpublished or published, and you want to try and get it registered unpublished because it's a lot easier. Well, not a lot easier, but it is easier. If I do a shoot, I'm registering that image within a day or 2 before the client could really use it, or post it anywhere. And I just register as.
Did you hear what Jack just said? You register it right away, all the time, as part of your workflow, especially if it's an assignment shoot. If someone is paying you to do the job, register it as soon as you possibly can, because it already has value and someone owes you money or has paid you money, and therefore it has value. Don't wait. Do it right away.
And I'll add that my workflow when I do a concert now is I come home, I'm up until 2 a.m. editing pictures sometimes because they need them by 6 a.m. or 8 a.m. Part of my workflow when I'm done with my edit is to export and register. It takes almost no time when you get the workflow down, and they're registered before I email the finished images to the client. But I think what they may be alluding to here that you were about to say, though, Jack, is there's a grace period, right, where you don't have to have it before.
Yes, Ed stepped on my presentation on that. So, yes, if the work is registered, there is a 3-month, not 90-day, a 3-month window where you can register it and still be protected. So, if you forgot to do it for whatever reason and the images ran, they ran February 1st, you have till March, April, May 1st to get it registered, and you're still protected within that window. They give you a little window if it's published work, because they realize because of deadlines and how things are done.
Right.
But if you do it that way, then you have to put the month and year, and it's just a little stricter, but if you're doing it right away, you shouldn't have any problem.
Just don't wait. Just do it right away. Yeah. You're buying yourself the possibility of aggravation. What for?
Yeah, it is an easy process once you do it. Thank you. I'll take the ball. So the Case Act we went over. I'm going to just zip through this. It's not a court. It's a process, and to me, it's more like mediation, arbitration. You have to have the image registered. to proceed with it. And the infringer can opt out without prejudice. We went over all of that. So what do you need to register? You need the images and the title list, which is an Excel form. Although, Steve, you use something else. You do it a different way.
I do it as a PDF just because it's my habit. Yeah.
Yeah. But they want a list of all the file names. And that's something fairly recently and is a big pain in the butt, quite honestly. You need to fill out the registration form that once you do it, you can zip through it. The first time is going to take you a little time just to understand what you're doing. But once you do it, it's really simple. And the third part is they want their money. It's $750 for, I'm sorry, it's $55 for 750 images.
Woo.
I'm getting ahead of myself. It used to be almost unlimited. I used to do like 10, 12,000 images from a trip or something under one registration for $35. Now they raise it to $55 and they limited photographs to 750.
Okay, Jack, let's repeat that again, because no matter how many times we do this, people misunderstand. So, Jack, if I register 25 pictures, how much will it cost me?
$55.
And if I register 555 pictures, how much will it cost me?
Let me do the math. Carry the two, $55.
And that's the same $55 fee as if I register 750 images. Is that right?
Correct.
Tomorrow, Steve, we're going to get an email from somebody that says, I can't afford to register images at $55 an image.
Yeah, it's definitely going to happen.
I'll bet you a bottle of Oban that 24 hours from now, that's the email we get.
All right. I just
bought
a bottle.
This kind of money.
Now let me interject here really quick for those that weren't here early. I have a video on my website on my workflow for registering images at behindtheshot.tv. If you search the word copyright, you'll find 2 shows these gentlemen did with me, plus my copyright workflow, and that'll be in the show notes. So there we go. Back to you, Jack.
I'm going to back up one slide. We also tell you they don't accept large files. The best thing to do is to send JPEGs. They will accept TIFFs and I think 1 or 2 other files types. You want to send in small JPEGs, and small JPEGs to me is anything between 600 to 800 pixels on the longest side, compressed to like a 5 or 6. So they're really small. Put it into a folder, and then that folder has to be zipped. They added a new little thing in the Copyright Office saying, do not upload pictures one by one. Put them into a folder, zip the folder. Very easy to do. That's the only way they accept it.
Hang on, boys and girls. What, did you see the question on the bottom there?
No, because I can't see questions because I have my keynote.
Did you see the question? The question that I just
Yes. Are you saying, there you go.
Here it is.
And it's Peter. Are you saying each photo registration is $55? That's very expensive.
Okay. So now, Steve, let me tell you where to send me the bottle of Oban. Make sure it's wrapped nice and cushy. It's amazing. It is
and Peter, let me just tell you, if you're shooting for a client, you're going to charge for your travel. You're going to charge for rental gear. You're going to mark up $55 to your client on your invoice to pay for the whole job.
How complicated is that, right?
I'll tell you somebody else who never registers their work. And
you called that so good.
I will tell you there is one group that does not register their work, and that's wedding photographers, which is a huge mistake because, and Ed loves this story. He's going to jump into another story here, but about a wedding that he loves. But before he does that and wanders off, you shoot a wedding and you don't know, like one of those guys suddenly goes out and is front page news because I won't even get into the situations, but think of any situations where Joe Schmo, who was such a nice guy, he was so quiet, we never expected this from him, and now he's front page news. Those images are worth a lot, and Ed has represented people in those situations. We had one person we used to show a lot. Oh, and I have it coming up. So I'm going to skip over that until we get into Ken Knight. Yeah.
Okay.
Well, don't say it. Don't give it away. We're going to get to that very, very shortly. That's coming up in just a minute. Why don't you wait till I get to that before you tell your wedding story, Ed? Because it'll make more sense. So again, small JPEGs. So small JPEGs, it is public record, so there's no reason to send in big files on that. It just has to be big enough so that it can be reproduced in court to show that that's your image. You cannot mix published and unpublished images. Excuses creatives use not to register their copyright. One of them is expensive. To me, it's the cost of doing business. I've collected on several infringements, thanks to Ed, and believe me, it'll more than cover anything I ever spend on registration. It's worth that much. People have camera insurance. Registration is image insurance to me, and that's why I do it.
They would think nothing of spending $50 to take a potential good client to lunch or dinner or for drinks. That they would think nothing of to get a job. But as we say in New York, God forbid they should pay $55, which gives them the ability to recover tens or hundreds of thousands of dollars. The burger makes sense. The money doesn't.
So these are some of the excuses we hear all the time. It's a low-res image. Nobody will be able to reproduce it. Ed could go on forever on this. I'm not going to get into it.
I'm going to do it real quick. Big case we had, 12-pack of a beverage, very worldwide beverage that everybody who's watching has seen or imbibed in. And
especially if you're watching a football game,
and
you
they
will
had
imbibe on this beverage.
That was distributed worldwide with 8 low-res images. And had I not seen it, I would never have believed it. A massive, expensive consumer campaign, all low-res images.
And especially with the new Photoshop thing they have where you can upsize your images, that's been getting better and better. So it doesn't work anymore to say it's a low-res image. I don't have any worries. They say it's not a professional image. Doesn't matter. There's been some amateur images that have been worth mega bucks. It doesn't matter if you're a professional or a non-professional. It's an image. It's a photo. It doesn't matter if you're a professional photographer or an amateur. And this is the one we like, and we're going to go into a little bit. It's not a famous fancy schmancy photo. I will tell you, one of the pictures that I'll show one that I did collect on, but there's one I can't show because of a non-disclosure agreement. I have to say is if somebody handed this into me in one of my classes or something, I'd flunk them. It was a nothing picture of something, and Ed collected a good amount. It was not a fancy picture or anything that I'm known for.
We dealt with the sale of a stock agency. The stock agency's most lucrative photo over a period of a decade was a photograph of a wave. It was a perfectly nice, perfectly fine photograph. And they made 7 figures every year over this very routine photograph that could have been taken by any high school student. And it wound up on every vending machine for Aquafina water and several other products. Just a wave.
So we're just going to get into this. So here's a picture taken by somebody who called me and then became one of Ed's clients, Ken Knight. This is the picture. It's, face it, if he entered this in a competition, would this score? I'm embarrassed to tell you what I would score on this. And it's not pretty. And he knows it. Ken wouldn't say anything that this is a masterful picture or a huge work of art. Ken collected numerous times on this image. And the reason he called me is, what to do. Ed, who happened to have been in Washington, D.C. by chance, said, we're registering the image right now. He ran through the Copyright Office, as he said, this was years ago, and got a registration that day because it was being.
Who can guess why this image has value? Anybody in the audience
Not counting Steve because he's heard this lecture.
Well, Steve will give you a bottle of Oban as well if you get this right. Why is this picture valuable? Anybody
Steven said it's a famous athlete.
Nope. You want to go to Potpourri for 200?
This one, I know where all these bottles of Oban are flying around.
Somebody guessed, is it the brand of clothes?
Nope. This is Jason Alexander, but not the one from Seinfeld, the one who was married to Britney Spears for 55 hours. And the media, the picture of this guy, and the star has locked up all the photo rights. So everybody stole it. Can I now tell the wedding picture story?
Sure. Yeah, let me just go to one, just two more, and then you'll tell it. Talking about weddings.
As a child, at a wedding of somebody, and this picture appeared without the photographer's consent, and therefore there was a copyright infringement. And at this time, Britney Spears was a 14-year-old tween living in Louisiana, and was you should forgive the expression, a nobody. By the time this picture was used, he was a big shot.
So two more quick images, and then you can tell your story. This was one of the images that was ripped off by, it's my image, and this paid for my Prius in cash, among other things. And this was just a simple shot I did for a company. They called me complaining that they saw it on a coffee website. I can talk about this.
You blew my line.
It's okay, because we got a lot. We're way behind. I want to keep moving forward.
This is a biracial child, and at deposition, the advertiser, I asked him, why would you use a child to advertise Martinson Coffee on his website? And his answer was, I can't make this up, his answer was, because she's coffee colored.
This is a long story we're not going to go into. And Ed, I'm going to get into derivatives. This is a picture of nothing, which is actually better than the other picture that I collected on from Ed. But I want to talk about influence versus copying. And Ed, let me just get through this really quick because it's a long one, and I want to get through it. And for us, copying is stealing, pretty much. Derivatives and protectable elements. So you got to be careful with derivatives. This is just an explanation of what a derivative is. We've talked about that before. It's just a work that is based on a pre-existing work and has been changed, condensed, embellished in some way. Yeah, there is no percentage change. We talked about that. Doesn't matter what the percentage is. This is one of my photographs, and I had an art director make a painting of this. And if he didn't ask permission, which he did, it was somebody that I really liked and we worked with a lot. I said, no problem. He showed it to me. If he didn't get my permission, this is a copyright infringement, even though it's a painting, even though he changed the angle, the color of the turtleneck, he added a bunch of birds and stuff, doesn't matter. Now, the other question we always get about derivatives and things is, what if I change it? It depends. As long as you can see that one was derived from the other, I just register the original raw image. If I feel I've really gone to an extreme changing it, then I'll re-register it. So this is an original image. This is what I did to it. The background is another picture that I took that I've also registered, and I added a lot of texture. I did not re-register it. As far as I'm concerned, this is a derivative of my original image.
So this actually is a question that Rebecca mentioned, which is my client asked for changes after I've registered the images, and I have to do multiple editings on the same images. How do you handle registration? I mean, what made you decide not to re-register that?
And this is really rough. Ed can go deeper into this, and I'm not going to let him. But it's the test in court is the average man test, basically. If the average person or an average person within a particular community can hold up the original and the derivative, the one that's been edited, and say, oh yeah, this is a derivative of the original. That's the test. So if you've done it to a degree where you can't see that it's the same image, then you should re-register it.
But Jack, the kicker is you're the creator of both. If you're the creator of both the original and the derivative, there's no issue. If the creator is Jack of the original and the creator of the derivative is Ed, Ed may have a problem.
So let me continue. So I want to talk about influence. And this is really important and very confusing to people. Norman Rockwell, great illustrator, who did all these great illustrations, a lot for Saturday Evening Post about Americana and these funny situations and people in these particular positions and postures and things, just comedy. And when I first got started in the late 80s and in the 90s as a commercial photographer, I was known as a photographer who did Norman Rockwell style work. And this is some of my images from back then. This is for PC Magazine and Reader's Digest and a whole bunch of other clients. But you will not see any of these as a direct copy of Norman Rockwell. They're influenced by that type of illustration, without a doubt. This is a good friend of mine who was in 6 Feet Under for a long time, an actress. Anyway, I'll continue. So these are just images where you look at, you could say, yes, I can see a Norman Rockwell influence, but not a copy. And here's Married Life. And I had a cover of Time and some other stuff. So I saw this magazine cover from PPA, which I was president of quite a while ago. And this was in an April 2017. They called April Copyright Awareness Month. I saw this and did a head slap because this is not an influence of Norman Rockwell. This is a copyright infringement. And I couldn't believe it. This is the original image that it was derived from. And I'll put them right next to each other. And a lawyer like Ed in court is going to go look at this picture and saying, why is it infringement? Well, it's all the same people. The cabbie on the left has the same hat. His leg is in the same position. The pants go up halfway up his calf. It's a white sock. He has his keys dangling. He's got his book in his hip pocket. The girl has a bow in the back of a blue dress. She has the same hair thing, same corsage. The guy have a pencil behind his ear. The guy in the chair is holding another pink sweat. It's copied exactly, point by point. This is not an influence. This is a ripoff. This is an infringement. And quite honestly, if the estate of Norman Rockwell,
who was
Norman Rockwell Museum,
very aggressive, by the way, very.
They can sue over this. And the photographer said, oh, this is an homage to Norman Rockwell. No, it's a copyright infringement. But this type of stuff can get very confusing sometimes.
I would say so. Somebody just made the comment that any parody could be a violation.
No, there are exceptions for parody and satire.
Which is our next two slides, funny enough.
Which the prior, Jack, if you can go back to the PPA thing, there's no parody here. What's the parody? Just a copy.
It's not a commentary or anything.
Right.
It's a direct copy without making every effort to reproduce it.
If the three people in the photograph that's on the PPA cover were, and I'm just going to grab three names out of midair, Tom Brady and Donald Trump and Madonna, then arguably, if there's an article inside talking about 21st century culture, then you could say it's a parody. Right. But each person, each model looks like the same person or the equivalent person in the Rockwell image. There's nothing parodying it.
Okay, well, let me continue because I'm also going to talk about Andy Warhol and some other things that always come up on these types of discussions with photographers. But here's another Norman Rockwell, The Runaway, it's called. A little boy running away, and you can tell that, the cop's leaning over. He's got, in those days, on a stick, he's got everything in a handkerchief, all his possessions. Fine. Here is a parody that was in Mad Magazine. And this is a commentary on the government sending military-grade excess military stuff to police departments. And the boy is now an African-American boy. It's been updated. This is making a statement. This is a parody. And this is perfectly fine.
And look at the look on the face of the soda jerk. He's looking at the cop with suspicion. And in the Rockwell, he's looking at the kid with a smile and a cigarette in his mouth.
Ed, we can't call them soda jerks anymore. It's a soda person, soda counter person. So anyway, this is another famous picture of Miles Davis again, probably the most famous jazz album out there. This is really, really famous, Kind of Blue, taken by Jay Maisel, of all people. Somebody else named Scott Baio, who is an executive. I forgot if it was, I forgot the, I can't think of the name of the company.
The record company.
No, not the record company. He worked for like Yahoo. That was it. He was like one of the big executives at Yahoo. Anyway, he did this tribute album. He licensed the songs and paid for it. He produced this and he said, "Oh no, this is a completely original work. It's digital art and really has nothing to do with the photograph." Well, he got contacted by Jay. They decided that they didn't want to go to court and spend money on lawyers. Jay settled for $32,500. I called Jay and said, you could have gotten more. And Jay said, we figured this would be fair without paying lawyers. So they settled for this instead of going to court. But just another story. So people always say about appropriated art, what about Andy Warhol? And this is a big thing lately. We'll talk about the Lynn Goldsmith case specifically, but first I want to go, people say, hey, Andy Warhol never got permission. What about that? What about the Campbell soup? And he copied that. Well, here's the thing. The copyright owner of the Campbell soup can is Campbell Soup. And they said, what's the benefit of suing Andy Warhol? This is free advertising. This is keeping our name out there, and still is. For them, there was no upside in suing him and stopping him. They wanted more. They were more than happy for him to produce this.
This is arguably the cheapest, best ad in history. We're talking about 50 years later.
So here's 3 silk screens that Andy did. This is Race Riot by photographer Charles Moore, based on his picture. This is Flowers by Patricia Caulfield. And I will tell you, I saw one of these hugely printed up at MoMA, the Museum of Modern Art. And this is JFK's funeral taken by Fred Ward. These 3 photographers, when this series came out, contacted Andy Warhol and threatened to sue him. Andy's lawyer told him, you're in trouble. Andy freaked out. He settled with them. I don't know what the settlement was. I think they got a piece of it, and I don't know if they got money or not, but it was settled to everybody's satisfaction.
In one or more of these cases, as I recall, don't quote me, Warhol gave a copy, which of course was worth and is worth more than the money that would have been recovered at that time in court.
Okay, so let me continue. So after that, Andy found out that he either licensed to get permission to use something, or he simply asked permission, and people were thrilled to give him permission. In the case of Disney, I'm sure he had to pay for a license because Disney will sue. Here's another very famous piece. This is by Robert Rauschenberg, who's collected in museums and sells for beaucoup bucks. The picture of the diver was a well-known picture, diver by Morton Beebe. In fact, that was his logo. It was recognized right away. Morton contacted Rauschenberg, and they ended up settling too. Rauschenberg paid Beebe's legal fees, and he gave him a numbered pulled print of Pull, which is the name of that. And he promised that whenever it appeared in print, BB would be acknowledged. This is another famous one by, photograph was by Sam Abel for Marlboro Cigarettes. I believe this is Sam's picture. He was one of the Marlboro photographers. And this was reproduced by the infamous Richard Prince. He re-photographed it. Richard Prince said, I used a cheap commercial lab to blow up the pictures. I made additions of 2. I never went into a darkroom. He went into one of these places that will blow up your picture for $30 and make a big, poster size. These sell for millions. And people say, well, why didn't Sam or any of the other Marlboro photographers sue Richard for using their image? Simple. Same problem as with Campbell Soup. They did not own the copyright. Back in the 70s and 80s, if you were photographing for ads for cigarettes, they paid for and demanded your copyright, that you turn over the copyright. So
which
while
you never, as a photographer, which you never ever do unless you're getting enough money to retire. Ever.
And, well, I got to tell you, back in those days, they were paying beaucoup bucks. And there wasn't a photographer who would turn this down.
Right.
But there's other instances too, like the very famous picture of the Vietnam prisoner being executed in the street by Eddie Adams. Great, one of the big historic pictures of all time. Eddie Adams was working for United Press at that time, and as a result of that, the work was work for hire. Eddie did not own the copyright to the picture he took.
But Bill Epridge, who took the photo of Robert Kennedy dying in a dishwasher's arms, did own the copyright, and he never sold the copyright to that image.
Yeah. We have numerous stories about this, and some that I'm not going to go into because I want to get into some other stuff. So this was another famous one where Richard Prince took these images off of Instagram, put them up in a gallery, and sold them for beaucoup bucks. And boy, did people complain and moan and groan, and how could he do this? You know why he did this and how he could do this? Because people did not sue him. They didn't register their works. They didn't know what to do. What did? They went on social media and bitched and moaned, which isn't going to do anything. Except for there was one photographer, Donald Graham, who sold fine art prints. I'm guessing at this point that they settled. Initially, they were going to court, and there was a settlement, and that fell apart. And then they were going to court again, and I haven't heard again about this. So my assumption is that it was settled. If it's settled, they can sign non-disclosure agreements, and we'll never hear what the result is. But he was, I think, the only one. I think him and maybe one other person were the only two that sued Richard over all of this, and he had a great case, and I'm sure he collected good bucks.
So
that is known about.
For example,
but I will tell you, there were a lot of people that simply didn't sue him.
98% of the matters that our office handles are unknown to the general public, are not recorded in any court, and don't appear in any magazine or newspaper.
That's a good point too, that a lot of people saying, oh, I don't want to sue because it's going to be too expensive. Ed, would you say easily more than 95% of infringement cases are settled?
Pre-pandemic, in the 12 months before the pandemic, in effect, closed the federal courts, 0.05% of all copyright cases started a trial. Started. It means that some of those settled during the trial. So at the end of the day, based on 42 years of experience in courtrooms all over the country, I would guess, educated guess, that perhaps 0.1% of all copyright cases go to trial and get a decision from a judge or a jury after trial. Perhaps 0.1%.
Yeah, one of the things that drove me crazy is when everybody was pushing for the Case Act, which was fine, and we're for that, and it's a good thing.
I'm not.
One of the things.
No. Well, I'm not.
Yeah. Yeah, I know. I'm not going to get into that now. That's another session, Ed. That's another session. The only thing I want to say, let me finish my thing first. One of the things that they were pushing out there was it costs you hundreds of thousands of dollars to pursue a copyright infringement case. That's true only if you end up going to court and actually continuing the case.
No. I didn't want you to go there. That's true if you're Apple, Oracle, Microsoft. If that were true for photographers, I would still be fixing cars. I wouldn't have a living. If it cost my clients hundreds of thousands of dollars to bring these lawsuits, I wouldn't have a business. It's preposterous. It's ridiculous.
But it was a scare tactic to try and get people to push this forward.
That's right. And stupid people, or people who don't know any better, or people who are naive, are easily scared. And it's simply not true. I wouldn't be in business for 42 years if it were true, or if it were 1/10 true.
Yeah, and your wife would have left you years ago.
Definitely.
Here we go. He's celebrating his 41st anniversary, just as I am this
summer.
My
wife is. My wife is.
She's celebrating. You're just there. Here we go. So this is another famous case, Patrick Carreyrou versus Richard Prince again. And Prince claimed fair use in this. And this is what it was about. It's Patrick Carreyrou lived among these Rastafarians for years so that they would get to know him and accustomed to him. And he did this little book on the Rastafarians, and Richard Prince ripped him off with these images. Richard Prince lost in lower court. He got killed by the Judge Batts, who just passed away a year ago. And he got murdered in it. He went to appellate court, and it was a very confusing decision. The art books are saying, oh, Richard Prince won this. This was appropriation. The court said this group of pictures, of I think 20, were considered, I'm sorry?
It was a total of 25, and they put 20 in one category and 5 in another.
Right. They said 20 of these were new creations, that he did enough changes that it was a new work of art. So it was fair use. We're going to get back to that in a minute. But 5 of them, they said, were a infringement, and send it back to lower court to Judge Batts. At that point, it disappeared, meaning that it was settled. And we will bet dollars to donuts, or Ed's favorite drinks, dollars to Oban, that Prince settled with Carreyrou and wrote a very large check to him. We don't know because it was a settlement, and it's non-disclosure. You won't hear anything about it. They won't say about it, but it left a very, very confusing decision. The legal criteria for fair use, so we're not going to go into this, is these are the 4 things that the court looks at: the purpose of the use, the nature of the work, the amount used as it relates to the whole, and the effect of the use on the value of the copyrighted work.
And now, theoretically, all 4 of these factors are equal. So now when you get to the Goldsmith case in a second, the judges say something recognizing real life, because in theory, while all 4 of these factors are equal, in real courtrooms in real life, they weren't. Now you're going to go to Goldsmith, right?
No, I'm going to go to a couple other things and then Goldsmith to go through this. But what Ed's saying is in previous cases like this, when they were looking at the purpose of the use first, and in Lynn's case, they actually went down to the effect of the use on the value of the copyrighted work, and quoted stuff in the Carreyrou case. So I just wanted to show this. This is a photo by Art Rogers. It was a postcard. It was produced by Jeff Koons as a sculpture. Art Rogers sued and won. This is a real landmark decision on this, and this negates the thing. Well, oh, it's a different media. Doesn't matter. By the way, Jeff Koons just lost 2 similar cases in France just this past year. I'm not going to go into that. And then I saw this somewhere. This is Triple Popeye by Jeff Koons, and Petapixel ran this headline. And I got to read it here because I can't read it there. Did Jeff Koons just make $28 million, because that's what he sold it for, plagiarizing a Dark Horse Popeye toy? Dark Horse is the name of the company that produced the toy. So this ran, and if you follow the story, they ran this soon after, and they said, whoops, oh, it didn't come up. No, he had, did I have the update? Yes, the update. They said, no, he had permission to copy it. He licensed it. He knew he could get sued over something like this really badly. So he paid for a license. And that is what normally happens these days.
And the real significance of this case is that the creator of Popeye, Fleischer, is related to me, and I've never, ever seen a dime.
And we don't care. We don't care.
Nobody in the family's ever seen a dime for 100 years. So my mother used to say, oh, you know, he's our uncle. I said, so?
But Ed still eats all his spinach. So
yes,
it's a win. So a big win for photographers. We got you, Ed. A big win for photographers regarding appropriation or fair use was the Andy Warhol Foundation versus Lynn Goldsmith. Now understand, Lynn did not sue the Warhol Foundation. The Warhol Foundation, when she contacted them about them using her work, immediately turned around and sued her. She lost in lower court. It went to a higher court, and she won very decisively in a higher court. This is what the picture was. This is these pictures, by the way, are from the court papers. So that's one of the reasons.
And pay attention, folks. This may sound like getting into the weeds. This is very, very current and very important. So
yeah, this is a huge, huge landmark case.
Put on your thinking cap here.
So this is where they ran the picture in Vanity Fair in '81. This is the picture that she took. Pretty, straightforward picture against white, but she did the makeup and she did the eye makeup on him. And this is from the court documents where they took one and laid it over the other. And the Warhol Foundation was saying it created a whole new thing. It gave him a different feel, blah, blah, blah. The courts killed Warhol in a bullet. They said it's still based on her image. That's the basis of it. And I'll tell you, a lot of people are in the art world want to see the Warhol Foundation win this case, because it just helps their appropriations artists saying, well, if we take something like this and we do this, we're creating a whole new piece. The courts finally made it clear by saying, no, it's not a new piece. It's a derivative piece of the original. And they did quote extensively the Carew versus Prince case, which they corrected what they felt were some errors in that case. They also talked about derivatives with movies, as I said earlier. It could be the book The Irishman, a movie by Scorsese, The Irishman. It's still based on the book, and the book is the source material for it. Ed, do you want to say anything else on this case?
I have. I can't get into too much detail, but in this current case, the judges correctly said that Goldsmith is, in effect, in the business, and she's selling these images, and you're undercutting the value of the commercial images that she's trying to make a living on. Now, I have a case currently where 20 some odd seconds of film was stolen from our client's film, made and copyright registered decades ago, and was put into a new film. And their claim was that, well, it was fair use. Yes, you had a copyright to it, but it's only 17 seconds and it's fair use. Except, and this is what may make the newspapers, in the 17 seconds, they inaccurately described the people in the image as, and I'm paraphrasing, criminals. They libeled these people, and in the film that my client shot, they were innocuous, lovely people. So you can't allege fair use while at the same time libeling somebody. You can't. In this case, let's forget the decision. In this case, if Warhol had portrayed Goldsmith's image of Prince as if Prince was a convicted pedophile, he could not claim fair use because it is not fair. It's not making something more accurate. It's not transforming its value. It's simply libel. It's simply something that you can get sued civilly or criminally for.
Well, we're really, we've got a couple more things I want to really get through. And if any of this stuff has been confusing you up to this point, this will confuse you a little more. So not everything is copyrightable. And a lot of photographers don't understand this. I just had a call from a friend very recently about one of these things. Certain things are not copyrightable, like titles. Ideas. And ideas are where photographers get confused. They think that somebody copied their picture. Sometimes they only copied the idea of what you're doing, not the actual expression of it. And that gets very confusing. We're going to show you a couple examples of what we mean by that. But some of the other things, such as facts, such as data, like if you're old enough to remember a telephone book, that's not copyrightable. Recipes are not copyrightable. Some certain facts are not copyrightable. I think I did, titles is the first one. So titles of books and movies aren't copyrightable. Short phrases aren't copyrightable. They might be trademark, but they're not copyrightable. Just do it is a trademark.
Or a service mark.
Right. Expressions are not copyrightable. Useful articles such as clothes. That's why when a designer comes out with their clothes, the cut of the clothes and the way they are not copyrightable. That's why they can get ripped off within minutes of showing it out in China, because it's a useful article. And we can go deep into that. We're not going to. So photos need to have what's known as protectable elements. So one very famous stock shot many years ago were two hands shaking. So people did all these different shots, and it sold for some huge amount in stock that year. So everybody came out with different hands shaking, like that really tight shot down below. They were showing different ethnicities shaking hands, a businessman with a suit and a workman, all sorts of different things of two hands shaking. You can't protect that idea of two hands shaking. Now, the picture of the cartoon of me and Ed, we have Hawaiian shirts on. There's palm trees in the back, bright sunny day. If you got two other people in Hawaiian shirts in a similar type of background, those would be protectable elements. And even if you put different people in, that we could sue for. So here's some examples. Penny Gentoo was a baby photographer. Actually, at the same time I was doing babies. She gave her stock agency at the time, that was then bought by Getty, these images of baby on white. Getty sent out a notice saying, we're licensing a lot of these images of babies on white. We'd like to see more images. She sued saying they ripped me off. She lost in court. The court said, no, you can't own that idea of babies on white.
Well, wait a minute, Jack. It wasn't babies on white. It was babies on light boxes.
Yeah, on a light box.
That was her thing, that she wasn't just shooting them on seamless white, but she had put them on a light box to make them appear that they were
plexiglass, which I was doing and a ton of other photographers were doing at the same time. The court said you can't own that idea. Now, the individual pictures that she owned and that she could sue for, but not any other child. They would have to reproduce the exact same position or something. Even then, that's questionable. But she can't own the idea. Let me continue. Somebody photographed for Thomas the Tank Train, this picture for their catalog. They used it beyond the licensing period. He sued. He lost in court because the court said, you don't own a copyright to this. This is a picture of their product that they own against white. This was a picture from the court filing. And they said, there is no copyright here. You might have been issued a copyright, but it doesn't stand up. We're not going to allow it. Now, if he shot the exact same thing with a kid playing with it, or he shot just this with a wide angle lens with different colored lights against a unique background, then those would be protectable elements and he'd have a case. But a simple shot like this is not copyrightable. It's also known as scenes affaire. It's a French expression, scenes that have to be made. It's also known as a merger doctrine here in the United States. I'm not going to go deep into this other than the bottom. It says a motion picture about the South Bronx would likely feature drunks, prostitutes, vermin, and derelict cars to be perceived as realistic, and therefore a later film that duplicates these features of an earlier film did not infringe. By the way, the South Bronx right now is very expensive. It's been gentrified.
Let me bring this up to date. So during the pandemic, only about 7 or 8 of my clients, so I can imagine that there's probably 8,000 clients, 8,000 photographers had the exact same idea. The New York City streets were empty. Take one person, put them during the day in a spot that is usually mobbed with millions of people, and show that they're alone. Now, the idea of showing a model or a person in Times Square at noon or on 42nd Street at noon, lying down in the middle of the street with no pedestrians and no cars, was only thunk up by a zillion people. So I have 8 clients who have various photos of a person, Times Square, Radio City, 42nd Street, 3rd Avenue, all places.
We got the idea. Keep moving, Ed. We're running out of time.
The idea of showing somebody alone on an ordinarily crowded street is not copyrightable. The photo itself is.
But things can get confusing. The picture on the left is an actual photojournalistic picture of a guy named Clark Rockefeller that somebody just happened to get as he was coming out of church with his daughter up on his shoulders. He was then convicted of a whole bunch of things, including murder, and is put away in jail. It's enough that Sony did a movie about it. The picture on the right is a PR picture of the movie, of an actor and a little girl actress on his shoulders. The photographer sued, saying they copied my picture of the scene. He lost because the court said, we can't give this to you because you can't own the rights to daddy giving a little girl a piggyback ride on his shoulders. It was just too generic, and the court didn't allow it. This is one by Peter B. Kaplan. Peter shot, obviously, the picture up on top. He saw the picture below. The court said, no, this is scenes affair. You lose this because you can't own the concept, the idea of a pair of shoes on a ledge about to jump. There's been too many changes in this case. And if they copied, so many things exactly, the same black shoes, the same type street scene, then maybe he has a case, but there were not any protectable elements in this. This is one where, this was, I think, not Microsoft. I think it was Microsoft, but they contacted the photographer on this. Frontier versus Ericsson. Yeah, I got the notes here. Microsoft Windows 2000. It's the old rules of business no longer apply. Negotiations broke down with the agency, with the photographer, because they didn't want to pay him, so they hired somebody else to photograph it. Photographer sued. He won. There were too many protectable elements, too many other issues too legally. But if you look at it, it's the same colored, polo shirt, same khaki shorts, both wearing sandals, both having a briefcase. The same type of pillars behind him is in the other case. And they said, no, this is a ripoff. So these things.
And there's a
go ahead.
These 2 photographs were taken 500 feet apart. One building is New York City's municipal building, and the next building 500 feet away is the courthouse, and the pillars on each building are the same, and the buildings were built at the same time and were both owned by New York City.
We don't care.
No,
all we care about is the photographer won.
But
You're
the
lawyering
court,
it.
but the court cared, because if the second photo had been taken without the columns, and let's say on a beach somewhere or a boardwalk or in Los Angeles, it's kosher, it's fine.
Okay, let's continue. Do watermarks mean anything? This is an article we have on our website, the Copyright Zone, if you Google for it. It is
Great
called The
article,
Value
by the way. Really good article.
I wrote all of it.
Yeah, right. You owe me a bottle of Oban. And if somebody removes your watermark, it proves willful infringement. There is no legal protection from a watermark. But if somebody removes it, now you're talking about two things. One, willful infringement in a copyright infringement case, and you can also sue them for a DMCA, Digital Millennium Copyright Act violation for removing it. Ed can go for quite a long time to explain this to you. We're not going to do that. I'm going to cut him off. You can read the article. It'll explain it much further. But I do want to say, isn't that a pretty picture? When you do a watermark, you do not have to do this. This is counterproductive. It's ugly. There's no reason for it. I get just as much protection from a watermark this big as a watermark this small in the corner, if you can read that. I think I have it blown up. Just as much protection, and I can make it even smaller. It doesn't matter. It just has to be there. In fact, I bring the opacity down usually when I do this. I just want it there. I don't want it to be overriding. I will sometimes, if I want to be overly cautious, I'll write all rights reserved. And we're not going to get into that, Ed.
But it doesn't matter if they clone it out or crop it out. Removing is removing.
Correct.
Exactly.
Okay.
Exactly. Also, this is 2021. It's time to change the dates in your camera metadata. I do this all the time. Every year I go into my Canon, copyright information, display copyright information. I'll change 2020 into 2021. So every picture I take has that in the metadata. What I'm going to do now, I'm going to stop sharing.
Jack, I got to add this right now. Because I had this conversation with the senior technical writer from the New York Times. This is extremely important, guys and gals, that your metadata reflect the shot. So I was speaking to the senior technical person who wrote this article entitled "Your Face is Not Your Own," and she had absolutely no knowledge of the ability to use digital quote film with metadata to demonstrate that one image is a copy of another, or that one image was shot with a particular camera at a particular time in a particular location. This is the senior technical writer talking about your rights to your biometrics and facial recognition software. So it's very important that each of your images maintains and contains this software, because if we're suing for copyright infringement and we give them that information, we're done. Our case is proven. It makes the lawyers' lives easier. It makes the cases easier. And if you have that software in there, you're a winner.
Okay, I want to try and get to some questions. So we only have a couple minutes. Steve, I don't know if you have some. I'm trying to go through some of them.
I've got a couple right here. So first of all, we were talking earlier about, that it's not hundreds of thousands of dollars if you end up having to go to court. Granted, overwhelming majority don't make it to trial. But if you go to trial, Nick Seth Smith asked, so what is the cost if you have to pursue a case?
I'm going to talk really fast, which I'm not accustomed to doing, but
no kidding.
When my office, I'm speaking on behalf of my office. When we have a really good case, we take it on a contingency basis, which means we get a percentage of the recovery, depending on whether we've settled the case before trial or gone to trial. If we lose, we get zero. We get paid nothing. The usual expenses that a client is liable for, it's a $400 filing fee to file a case in any federal court anywhere in America. That's the fee. That's another reason why you never, ever, ever, under any circumstances, agree to arbitration, ever. During the course of a trial, the expenses for trial are generally for stenographers when you take depositions, which depends on the trial, could run anywhere from $500 to $10,000. It depends on the trial. And typically we hire experts. Some of the experts will testify for free or for small amounts of money, and some of them charge significant amounts of money. So you can have a case. I'll just pick one off the top of my head. There's one case that settled for just under 7 figures, and the total expenses by the photographer were about $40,000, and the settlement number was just under $1 million.
Okay.
Ed, let me just jump in on one quick thing on that a lot of photographers don't understand. When you first contact a lawyer, you're not getting charged. You're going in to find out, is this a case? Do I have something here? At that point, a lawyer will tell you what the situation is, if it's a good case, if he would take it under contingency, or I think I could just settle this. Ed says this to a lot of people I know. I can settle this with just letters. And that happens a lot. So the big fear people have over this is, as soon as I talk to a lawyer, I'm in for thousands of dollars. No, you want to go and say, is this a case? And if a lawyer's charging you to find out, like, turn around and run out. That's not a lawyer you want.
And sometimes, and there's one case in particular, unfortunately I can't use names, where a client comes in and outright lies to us. And I caught him and I threw him out of the office. And 3 weeks later, he begged, represent me. You're the only person who could represent me. So he hired somebody else and he lost, and he got fined by the court, as did his lawyer, because
we talk a lot in the book about what to look for in hiring lawyers, what lawyers think about before they take on a case, because they may not take you on for a variety of reasons.
We don't take any case on a contingency case if we can't trust that our client is telling the truth.
So let me ask, I've got 3 last questions. Let me do this quick round here. Stephen Scharf asked, what about photographing architecture and selling it as fine art? Who owns the copyright of the image, the architect or the maker?
It's not going to be an easy answer because it's a lawyer's favorite response. It depends.
I can do it quick.
It depends.
I can do it quick.
This I got to see. I got to see this. Go ahead, Ed.
Shut
up. Timer.
Certain architectural plans are copyrightable. So in cases such as that, some are copyright infringements, some are not. You have to sit down with it's a fact-sensitive situation, and sit down with a lawyer who knows what he or she is doing. There is no one-size-fits-all answer.
And a lot of what we've discussed here today is, you're getting into fine, granular legal details. Like, for example, Rick Goldsmith made the comment earlier when we were talking about copying and stealing and that type of thing, and said, semantics, can we not do recreation, as in taking 2 people to the same spots, dress and pose them in a shot from a movie? And you kind of answered that with the Microsoft shot that you did.
Well, can I?
Whoa. No, that's a little more complicated, I think, for an answer. Ed, let me just answer this one. And it depends on this it depends on what you're doing with that image. That image we saw about with Microsoft was an ad. If you're doing this for a wedding, for a personal picture, Ed might have a different answer to this, and we don't always agree on things. But as a business person, if I was doing that for a wedding couple and it's only going to show up in their wedding book, I wouldn't think twice about not doing it. I would do it. There have been things I've seen where photographers are ripping off like movie posters and putting them in the movie poster with all the wording and everything. That to me I know somebody who was doing that is a product line. I said, I think that's a big no-no. And if they see you doing that, you're going to get, the studio is going to go after you. But if you're reproducing something of a couple from, Titanic in front of the boat or something, I personally wouldn't hesitate doing it. Ed is probably going to say, don't do it, I'm guessing. But what's your
It
answer?
depends, but I do want to get in, Steve, before your next question real quick.
Yeah.
For all you wedding photographers out there, this is, to me, the quintessential wedding story.
He's been dying to tell this story tonight.
And it demonstrates the difference between ownership of a photograph and copyright in a photograph. So the facts are good and they're juicy. A made man is dumb enough to go to a wedding with his guma. And for those of you unfamiliar with the lingo, that means a woman who is not his wife, and he does have a wife. So after all these wedding photos are taken, this genius the next day comes to his senses and says, holy expletive deleted, the family's gonna see this. This is gonna get out. My wife is gonna see this. So he goes to the wedding photographer and says to the wedding photographer, hey, sweetheart, you can keep your copyright. I couldn't care less about the copyright. I want to see all the pictures that I'm in. I want you to give me all the pictures that I'm in. I'm going to give you this big fat check. If I should ever see my picture anywhere, you will not live to see breakfast. She has the copyright. He owns them. He's probably thrown them away and burned them. So sometimes ownership is more important than copyright. Secondarily, when you shoot a wedding, you may capture something. And in our book, we talk about there was a murder during a cruise. And the photographs show that this person got on the cruise and didn't come back. And those photos were worth a fortune. So
interesting.
Wedding
photographers next question.
Always keep the copyright all the time.
Well,
okay, Steve.
So
because we're over time
this
now.
is the last. Yeah, this is the last question, and the answer to this question may be what is the answer to a lot of this, which is register your images, and if you have a question, consult a good IP attorney in your area. So, and this is two parts. And answer as quick as you can, because we're over time, but I wanted to get this in. I promised Mark I would. With respect to jurisdiction, what is or are the defining factors with respect to actioning a copyright, i.e., a photo taken of an American citizen in another country by a citizen of another country? I'm guessing that that's not easily
answered. All right. Well, first of all, we're talking Jack, wait, Jack. We're talking about
Ed.
We're talking about a 6-month course in law school.
Okay, good. That's what I thought. That's the best answer.
Wait. So there are many factors that go into that, not the least of which is where did the people reside? Where did the transaction occur? What is the best law to take advantage of? And whether or not someone is not going to show up if there is a court case. I do want to add one other thing. Photographers don't like the fact, and it's understandable, that you don't have a mileage chart with a lot of legal issues. It's not exact like an electrician has a schematic. So I reply to photographers very cleverly. If you have any familiarity with a color wheel, how many shades of gray are there on a color wheel? It's the same thing in the law.
Let me give you my really short answer on this. And everything is completely 100% correct. We don't always agree on stuff. You can take a picture of people. What do you do with the picture is where the law comes into play. So I take a vacation. I take lots of pictures of people. I put them in a blur book for myself. I have no problems with that. If I put them in an ad, it's another story. Now, I did have one of my students who lived in Cairo, in Egypt. She took a picture here in the States I don't know where she took it. She took a picture of something that was ripped off by a consumer company that is based in Korea. She's in Egypt, they're in Korea. It showed up here in the US she sued here in the U.S. If it shows up commercially here, you can sue here in the U.S. But taking pictures, except for certain countries, it's not a problem, although some European countries now make it difficult, and there's moral rights to people. But generally, like here in the States, you can take any picture you want. What you do with it is where the law comes into play.
So let me say this then, because I had one more question come in, and I just basically told her that the answer was on model releases. And what I told her was, you address model releases in your book, and the 2 times that you were on my podcast, you addressed model releases.
Right.
So go look that up. And I'm sure you've got probably articles on that on the copyrightzone.com too. Right?
And there are pending cases if they go to our blog. The cases that we have for models, one, we represent 35 models. If they want to go to our blog, they can click on and read the papers that we've submitted to court. Okay. If it's a quick question, do it.
Sounds good. Then in that
we
case,
could do another 2 we could do 2 hours on model releases.
Yeah,
again, we did the first time you guys were on my show, we did an hour and a half, and I think the second time an hour and 15 minutes, and we could have gone longer. So I highly recommend their website. The book, The Copyright Zone, is on my shelf behind me and taught me everything I know about how I register my images. And I put a link in the chat, and it'll be in the show notes to my workflow. I've got a video on it. Troy, was there anything else you had?
No, I had a list of questions, and as Jack went through the slides, I'm like, oh well, okay, I don't have that. I'm getting texts from my friends.
Maybe.
Like Troy, why aren't you talking? I'm like, well, because Ed dominates the conversation. Jack just is allowed to talk.
I'm lucky.
Oh, no, Jack
I'm lucky to get some words in. I'm lucky to get something in.
Well, I will say, and Stephen just asked where the show notes will be. When Troy publishes the video, the link will go out to IEPPV members. Yep. And anybody else that's in here, if you want to see it at that time, hit me up on social media. I'll send you the links to everything once it goes up live. But Jack and Ed, as I said at the beginning, it is always wonderful to see both of you, and I hope that you guys are staying safe and well during this rather odd year.
Thank you. The same to you and yours.
Well, it's 2021, which is an odd year, Steve.
Yes, that's true. Odd year. And they're doing WPPI, which is really weird. Troy, did you want to do anything else? I think we got all the questions, so I'm guessing you didn't want to open it to anybody.
No, we're totally good. What I'm going to do is again, like I want to add what Steve said was thank you guys for coming on, and what an amazing amount of information. I mean, as a wedding photographer, you spoke a lot to me. I have a lot of images that are not registered, and Steve has been trying to get me to register things for a really long time.
Years.
And it's just I'm just being lazy about it, right? And I know
I'm gonna fix it.
That's
Troy, you're married, right?
For now.
Okay. So one day I may make a phone call to your wife and say, if Troy wasn't lazy, you could buy all those nice things that you wanted, but he was lazy. The kid's not going to college. You're not getting flat fixed.
Oh, she's been to college. She's hanging out in here. She's watching. She did good.
But before we close, there's 2 things I want to give out. 3 things I want to give out. First of all, The Copyright Zone is the book, and the website is thecopyrightzone.com. And then Jack's website is reznicki.com. That's REZNICKI.com. And then Ed's website is Greenberg IP Law. By the way, don't go get a real estate attorney. Get an IP attorney. GreenbergIPLaw.com if you need to reach out to Ed for anything. And guys, thank you so much. I love this. David just asked, by the way, this is a good question. David just asked, what's the best way to buy the book?
With cash?
Amazon.
Cash.
They're running out of the edition. I get a feeling
they're sold out. You can get a used copy, and there are some new copies. And as a New York Jew, there is absolutely nothing wrong with buying a used copy.
Okay, good.
There you go.
I think that's it, guys. Thank you.
Yeah, thank you guys so much for everybody that's that's hanging out in the chat, I'm going to stop the recording, and then you guys can hang out in here for a little bit if you guys want to talk to each other. Jack, Ed, you guys are free to go.
Does this mean I have to go to talk to my wife now?
Yeah,
Yes.
no, you don't have to. You can hang out.
No,
So,
you need to go pour yourself an Oban, and I'll do the same thing here, and I'll have a drink with you remotely.
Okay.
there we go. There we go. Thank you
Bye,
guys.
Jim.
Thank everybody for joining us.
Our pleasure.
Thank you, guys.
Delighted.